I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I rule, then that's not my problem.
Hey everyone, welcome back to the channel. Today we're heading straight into Judge Perkins' courtroom, where yet another self-proclaimed sovereign citizen tries to outsmart the entire US legal system. You know the type, armed with Google law degrees and a mountain of misplaced confidence. Judge Perkins has seen plenty of them, and trust me, this one's no different. Let's dive right in and see how quickly this house of cards collapses.
City of Detroit versus Christopher Perry Lewis, case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email? What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @gmail.
Chris CHRISL, right?
Yes, EWIE.
I don't have it.
Our self-taught legal expert can quote obscure constitutional clauses from memory, but somehow can't figure out how to send an email correctly. The irony practically writes itself. You'd think someone claiming to expose the system might start with learning basic tech, but no. Once again, reality delivers the punchline.
Okay, I'm resending it at the moment.
I'm gonna put my email address in the chat and I'll put my email so you'll have it, and send that to me, and I'll have an opportunity to read that. I'll confirm that you sent. I'll wait to confirm that you sent it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Dia Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her an attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions that it has. All right, I'm going to wait on that. Once I confirm that you gave me that, I will recall the case.
After what felt like a lifetime of failed attempts and probably a few frustrated keyboard smacks, our legal prodigy finally managed to send his masterpiece motion to Judge Perkins. But it only took the judge 2 sentences to realize it wasn't worth the pixels it was written on. That's when things got heated, because this sovereign scholar doesn't take rejection lightly. Let's just say the fireworks start now.
Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only
No,
2
I
pages.
can't, I'm not gonna read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for
Is
a
there any way I can
trial.
get a written, can I get a written articulation as to why you're denying the motion? Is there
I'm
any way I can-
denying the motion,
I would just
because
appreciate a written excuse. Can I get a
I'm
written
not
articulation?
gonna give it to you in writing. I will, what I
Are
will
we on
do-
record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm
I'm
denying
saying
that.
that. I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article
Uh-huh.
1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying the motion to dismiss, okay? I'll set a trial date for you so you can be heard on that type of forum.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay.
You get a
I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, as so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming.
Perkins denied the motion on site, and for good reason. It's the same recycled and sovereign citizen nonsense we've heard 100 times before. These arguments collapse faster than a house of cards in a hurricane. Perkins barely had to glance at it before realizing there was nothing of legal substance here, just another YouTube law professor caught in his own logic loop.
So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no
I'm
victim
not
or
your
no
man.
loss, bro.
I'm not your, listen, I'm not your man.
Look, sir.
Hey,
sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody.
Judge Perkins has heard this all before. Every variation, every supposed loophole, every YouTube-certified legal revelation, and yet not one of these self-proclaimed experts has ever presented a valid argument that holds up in court. It's almost impressive how confidently wrong they can be. Unless this guy stumbled upon a secret legal codebook the rest of humanity missed, we're in for another comedy of errors.
I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence, or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more from
cool.
you.
It's cool. I appreciate it. This is due process. This is a due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an injured party, sir. What are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. if you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever, wait a minute, let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
Judge Perkins generously offers him a jury trial, a fair shot, right? But when you claim everyone's part of a grand conspiracy, who exactly counts as your peers? Kindergarteners who just learned about sharing? Either way, this trial's going to be something to see. I'm not sure if we should bring popcorn or a law textbook.
I appreciate that, but I would still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not you know, I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages / losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that.
Quick legal breakdown. When the defendant calls Perkins an Article 1 judge, he's showing just how little he understands the system. Article 1 judges operate in the federal arena. Judge Perkins, however, gets his authority from the Michigan State Constitution, which in turn is grounded in the 10th Amendment. In other words, there's no Commerce Clause conspiracy here, just another sovereign citizen trying to sound smart by misquoting civics class.
Indicating a clear conflict of interest, I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right. So I'm dismissing the motion, all right? And you can get a copy of that record, on, of what we just made, by, going through the proper channels of the court to get the, court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court reporter is not going to respond to your voice message. The court reporter is going to respond to you
The
coming down.
36th district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is a distinct.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
We've moved past that getting locked out.
That was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
By this point, even Judge Perkins has had enough. So instead of arguing in circles, he sets a jury trial and basically says, let the people decide. Maybe, just maybe, hearing it from 12 ordinary citizens will make this guy realize how absurd his claims sound outside of his echo chamber. But if history's any clue, he'll just double down and call them all government agents. Stay tuned.
July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that day. So you're trying to play with me. You could dismiss it today, sir. You literally, but
a final pretrial 8:30.
You are literally violating my due process. You can't even give me a written excuse, but you're going to all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. I do. Excuse me, ma'am. I am in pro se. I'm in pro se.
Go wherever you want to. Final pretrial of July 22nd. I am. Is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
And that wraps up today's courtroom chaos. I'm officially back from my trip and ready to dive into more wild cases just like this one. Seriously, the support you guys showed while I was away, the comments, the jokes, the love, it all kept me going. You guys make covering this madness worth it. If you enjoyed the video, drop a like, leave your thoughts below, and make sure you're subscribed with notifications on. There's plenty more courtroom drama on the way.